art, a ritual, a discipline. I would request all the dignitaries on the dais to come forth for the spiritual act. As we light this lamp, let it symbolize the eradication and promotion of a healthy lifestyle. Thank you, esteemed dignitaries. Health is wealth. Health law is the means to grow, maintain, and develop our inner wealth in the most sustainable manner. Because he who has health has hope, and he who has hope has everything. I, Dr. Seema Siddiqui, as the head of the Department Faculty of Law, welcomes you all in the introspection of the health. It is with great honor and enthusiasm that the Faculty of, in collaboration with the Faculty of Medicine and Health Sciences, announces the commencement of the International Conference on Convergence of Health, exploring legal and medical perspectives. This gathering is a testament to the growing recognition of the interference between the legal and medical fields in addressing these of the modern health challenges. Flowers always make people better, happy, and helpful. They are said to be the sunshine, food, and medicine for a healthy soul. Keeping up the tradition, I would request Ms. Disha Veer to present the bouquet of flowers to our respected patron, Dr. Syed Nadeem Akhtar Sir, Honorable Pro-Chancellor, Integral University. I would request Zoya Hashmi to present the bouquet of gratitude to the chief guest of the event, Professor Ved Kumari Ma'am, Honorable Vice Chancellor of the National Law University, Orissa. Ms. Mantasha to present the sprig of happiness to the special guest of the event, Professor Shikhar Ranjan Sir, Director ALCO, Legal Advisor to the Medical Council of India. Ms. Shruti Giri to present the bouquet of humbleness to our special guest, Dr. Ulfan Hash, Director Health Systems. Praise to our co-patron of the event, Sir Haris Siddiqui, Registrar, Integral University. Ms. Bushra to present the bouquet of freshness to the Dean, Faculty of Medicine and Health Sciences, Professor Abha Chandra Ma'am. Last but not the least, I would request Guncha Naqvi to present the bouquet of flowers to our Dean, Professor. A good commencement marks the true success of any event. To lead this international conference into the realm of success, I would like to invite Dr. Naseem Ahmed, Dean Faculty of Law, to deliver the welcome address.
Good morning to one and all present here. I am deeply honored to welcome such esteemed and knowledgeable individuals, including professionals, researchers, advocates, and students who have gathered here from across the country and around the world. I, Dr. Naseem Ahmed, on behalf of the organizing committee, extend my generous welcome to our Co-Chancellor Syed Nadeem Akhtar sir, who is also gracing the event as patron. I express my heartfelt gratitude and deepest greeting to our eminent academician and chief guest professor Vivek Kumari, Vice Chancellor, National University, Odisha. To Professor and Advocate Shikhar Ranjan, a renowned personality in legal practice. Professor to the medical advisor. I express my gratitude to our special guest, Dr. Vashni, Deputy Director, Health Service Delivery and Human Resources for Health. Dr. Harsh, Medical Education, Research and Education. Special World Health Organization Reward. My sincere appreciation goes to our Adnan Akhtar sir, Director D. Lucknow. I warm welcome to Professor Abha Chandra, Dean of the Faculty of Medicine, and who was always available and prepared. A warm gratitude to Examination Chief Proctor, Dean MD, Director IKC, Director CID, Director CCND, and other authorities of the university. Lastly, I extend a hearty greeting to our most valued guests, Deans, department, participant, colleagues, and my students. The new teaching policy is more research. It has always tried the its best to the achieve goal through academic excellence and cooperation with the government initiatives or goals. In this line, the Faculty of Law and the Faculty of Medicine are organizing this conference to promote research. When the conference theme, many ask about the connection between law and health. The World Health Organization Constitution defines health as the complete physical, mental, and social well-being, not just the absence of disease. Social well-being prompts law to protect people's interests and hold the state accountable. Article 38 of the Indian Constitution mandates the state to work for people's welfare, which is why the Indian Parliament has introduced the National Health Bill multiple times, although it has not become law today. This highlights the need to establish the right to health as a statutory right as seen in states like Rajasthan and Assam. The discussion about the right to health refers to the Indian Constitution. Article 8 of the Indian Constitution explains the right to life, including the right to health as well as the right to health. The Honorable Supreme Court of India held the right to health as a fundamental right. Additionally, international bodies have made significant contribution through international law, such as Declaration of Alma-Ata and the World Health Organization Pandemic Treaty Proposal and WHO Constitution, etc. However, despite these aberrations, the status of the healthcare system in India is not up to par. India's expenditure is the only 2.1% of the GDP on health. On the other side, countries like USA, Germany, Canada, and Japan spend more than 13% of the GDP on health. No doubt, India is becoming a health-tourist country faster, but our citizens are suffering from a basic healthcare system. Poor infrastructure, shortage of medical practitioners, medical negligence, and ethical issues are the main problem of the healthcare sector. Many doctors avoid working in rural areas and prefer practicing in urban area or abroad. This creates challenges for government medical colleges and hospitals that lack experienced faculty and renowned practitioners. These issues need serious attention from the medical community. Legal practitioners also need to understand their responsibilities and collaboration well with the government and medical sector and ensure the remedies for the public life if the right of health is violated. Because there is right, there is remedy. Due to this, during pandemic, the court heard petitions seeking affordability of COVID testing and treatment of directed them to government to develop a national policy for the pandemic. Maximum directives have been passed by the Supreme Court. They were raised by advocate through public interest litigation. Recently, in the case of publication of misleading advertisement by Patanjali, the court initiated on PIL which was filed by the Indian Medical Association. Having laws, policy, and guidelines is essential for setting standard and expectation, but their mere existence does not guarantee everything will be perfect. Implementation, enforcement, and on crucial too. Law and medical professionals are crucial players in reaching the goal of health for all. They contribute significantly in ensuring that everyone has access to quality healthcare services. Laws can establish frameworks for healthcare delivery, ensuring access, quality, and affordability of everyone. They can also suggest standards for medical education, practice, and ethics, promoting professionalism and accountability among the healthcare providers. On the other hand, medical practitioners are on the front line, providing essential healthcare services, promoting preventive care, and addressing health disparities. Collaboration between lawyers and medical professionals can lead to policies and practice that improve overall health outcomes and work towards the goal of universal health coverage. I hope this conference will be helpful for researchers and academicians who are working in public health. I appreciate the efforts of the organizing committee and the higher authorities for their unconditional support. It is a pleasure to welcome all the guests, researchers, and academicians to this center of academic excellence. I together in
University. In a very short span of time. I would like to request the co-patron of the event, Professor Haris Siddiqui sir, the registrar of the Integral University, to throw light upon the structure of this international conference.
Honorable dignitaries, dignitaries of the dais, deans, HODs, and Technical University for giving conference. Faculty of Medicine and Health Sciences. So it's time for convergence. Technology has come in place. University, the whole so if we see COVID-19, it couldn't have happened without that the doctors for the well-being had there no law, it would have been difficult to enforce are there in the hospitals of the patients who are suffering from COVID-19. At the same time, it was the law which ensured to safeguard the doctors for any kind of emergency or any kind of mishappening which happened during COVID-19. So as we have seen earlier in the biological sciences, when only MBBS was the option for a biology student, Now we have more than 150 options for a student who takes biology in class 12. At the same time, the profession of law has come forward, and it is now one of the top choices of the students. So it can only happen in an institution like Integral University, where almost the convergence of almost all the fields of study is happening. So with this intention in mind, the Honorable Chancellor and founder of the university started this great institution with a very small, humble beginning, with a small hut and 5 children in the year 1993, with a very small corpus of rupees 5,000. The foundation stone of this great institution was laid by a world-renowned Islamic scholar, Hazrat Maulana Abul Hasan Ali Hasni Nadwi. Honorable Chancellor, with his small dedicated team, but with sheer grit and determination, commitment and hard work, started this project with the ITI college in mind. But then in the year 1998, with the kind of infrastructure he could build in a period of 4 or 5 years, the Institute of Integral Technology came into existence with the abbreviations of IIT Lucknow. The then Prime Minister of India, Shri Atal Bihari Vajpayee, visited this great institute, and after seeing the infrastructure and growth in a very short span of 4 or 5 years, he categorically mentioned in his speech that he wanted this great institution to come alike as the IITs and the IIMs in the country. The institute was blessed to host almost all the governors at that time, Shri Motilal Vora ji, Shri Suraj Bhanji, Shri Vishnukant Shastri ji, in the period of 4 or 5 years, and they all supported this great institution in building this great institution in one way or the other, either by financial support or providing the technical and other political support. Based on its excellent placement, very good academics, and establishment of the entire Faculty of Engineering and Technology, with the students getting placed in almost all the reputed companies of the country, particularly the Institute of Integral Technology was elevated to a full-fledged university in the year 2004 by the then Chief Minister of Uttar Pradesh, Shri Mulayam Singh Yadav ji. The university, which started with the Faculty of Engineering and Technology, expanded in its wings in the form of other faculties, particularly the Faculty of Pharmacy, the Faculty of Architecture, Planning and Design, Faculty of Commerce and Business Management, Faculty of Fine Arts, Faculty of Mass Communication, and so on and so forth. The university got itself registered under Section 2F of the UGC Act 1956, and the university also applied for the registration under Section 12B, which is got in the year 2011, where the university became eligible for government grants for the students and faculty members. The university, apart from academics and placements, was always particular about research, and the kind of research happening in the university ensured that the university got registered as a scientific and industrial research organization by the Ministry of Science and Technology, Government of India, in the year 2012. The university was one of those very first universities which readily accepted the narratives of the Government of India, Ministry of Education, in going for the accreditation by the National Academic Accreditation Council. During the first cycle of accreditation, the university came out with flying colors and was accredited in the good category in a span of around 7-8 years since its existence. At the same time, the flagship faculty of the university, the Faculty of Medicine and Health Sciences, came into existence in the year 2023, followed by the Faculty of Agriculture in the year 2014 and the Faculty of Law in the year 2016. With the joining of our Honorable Pro-Chancellor, the internationalization of the university started, and the first batch of students from the Sokoto State, Nigeria, joined this great institution as the first batch of foreign students. At the same time, the university also expanded in terms of opening new programs in almost all the departments of study, and the student strength of the university reached to a point 13 to 14,000. The COVID wave, with its founding of engineering and technology, and quickly adapted university to its own integral learning management system, and very quickly the teachers adapted to online classes. The hospital quickly transformed itself to a tertiary care hospital which was taken by the government of Uttar Pradesh for the treatment of COVID patients. The management of the university ensured that there was uninterrupted supply of oxygen throughout the first and the second wave of COVID period, an account of the complete support from the management, the dedicated efforts of the Faculty of Health and Medical Sciences. The institute was able to achieve a recovery rate of more than 95%. The university also ensured that an oxygen storage tank costing around more than 50 to 650 lakh of rupees was installed on the university campus to ensure the uninterrupted supply of oxygen. Considering the exemplary services and the very high recovery rate, the Institute of Medical Sciences got rewarded by the government of Uttar Pradesh, by the present governor, Srimati Anandibel Patel, for exemplary services in the field of health and medical sciences, particularly for during the period of COVID-19. At the same time, Google was kind enough to give the university an oxygen generation tank as well. In the year 2021, the defense minister of the country, who had earlier visited this institution as the home minister of this country, raised the convocation as the chief guest. Although he had given only 45 minutes time, but he was so embraced with the campus life, with the infrastructure of the university and kind of environment this institution has. He there for around 4.5 hours, and after this complete analysis with his own eyes and ears, he was confident that the university will come out with flying colors in the second semester. It so happened he got reaccredited as NAC A+ University with a score of 3.4 by the national. At the same time, we can ensure that the education is reached to the doorstep of the people. At the same time, the distance education programs were also started. Once the university was A+ accredited, the university was also given the opportunity or allowed to open off campuses and offshore campuses. At the moment, the university has 4 campuses in the state of Uttar Pradesh. One campus where this conference is happening, that is Integral University Phase 1. The other campus is on the other side of this road, which hosts the Faculty of Pharmacy, the Faculty of Law, the Faculty of Agriculture, Science and Technology, Faculty of Humanities and Social Sciences. Of late, the university has also hired a campus which was formerly known as Asia School of Engineering and Management in the name of Integral University Phase 3. And one campus is already running since around 13 years in Shahjahanpur, that is Integral University, Shahjahanpur off campus. At the same time, the university is also expanding its wings to open more offshore campuses, particularly in this Nigeria, where Honorable Pro-Chancellor has expanded and ensured that we have students from almost all the states. At the same time, efforts are underway to open new campuses in Dubai, Kyrgyzstan, Uzbekistan, etc. With the patronage of our Honorable Founder and Chancellor and Honorable Pro-Chancellor and the leadership of Honorable Vice-Chancellor and his team, the university is marching ahead in its efforts and objectives to take this light of education across all the corners of the world. I am thankful to all the members of the Integral family, the students, the faculty members, and each and everyone for making us reach where we are, and together we pledge that we will take this institution to even more great heights in future. Thank you so much for giving me this opportunity.
Thank you, sir, for the complete genesis of our esteemed institution, Integral University. Collaborative activities marks the interdependence of the bodies. I would request Professor Abha Chandra ma'am, Dean, Faculty of Medicine and Health Sciences, to throw light upon the importance of the collaboration between law and medicine.
Good morning to everyone. This is indeed a very pleasant and a special moment to extend my warm welcome to the dignitaries on the dais and off the dais, faculties, delegates, and my dear students to this very exciting meeting, the International Conference on Convergence of Health, Exploring Legal and Medical Perspective, which is being held today in our campus. I would also like to say that this meeting is very interesting and a very unique one, This is for the first time I have heard of a meeting such where the Faculty of Law and Faculty of Medicine have come together to hold an international meet on a very important aspect, which is the medical legal aspects, which we as medical doctors follow. So both medicine and law go together. We talk about ethics in medical sciences. Legal issues in medicines may be related to practice, treating and operating patients, or law and medical legal reports, sexual offences, death, etc. So, to deliver a good quality care to a patient, it is the legal aspect also which we need to see and follow the ethics and give a good treatment to the patient. Um, this conference isn't just about talking, we need to make a move ahead. We aim to collaborate to generate new ideas, enhance existing systems, and shape a future where healthcare is equitable and accessible for everyone. It is an opportunity to deliver into the captivating realm where health and law intersects. Whether your passion lies in medicine or in law, this conference pledges to fuel your curiosity and empower you to enact meaningfully change. We are bringing together experts from the law and medicine to tackle some of the biggest challenges in healthcare today. Whether you are studying law or medicine, your perspective is valuable in shaping the future of the healthcare. I hope today you join for a day of learning, sharing, and making connections. Together, we can build a healthier future for everyone. I hope there are going to be interactive sessions throughout the day today. Your thoughts and knowledge matters much. So let us learn from each other and difference in the world. Thank you very much.
Thank you, ma'am. In a nation of vibrant contrasts, India grapples with a complex health landscape. The scent of urbanization mingles with the harsh tang of industrial pollution. All these and various other facets of the convergence of health and law has been collected and published in the form of the Sonnet of the International Conference. The series, the Souvenir of the International Conference on Convergence of Health, Exploring Legal and Medical Perspectives. Of the dais dignitaries also, please, the souvenir is in front of you. Kindly. Dr. Gulfam Ahmed Hashmi, Deputy Director, Health Service Delivery and Human Resources for Health, is a medical doctor with an MD in community medicine. He comes with an experience in medical education, research, and administrative fields with 17 years of experience in program implementation, policy and advocacy, project leadership, private public partnership, digital health innovations, and program development. Health and Nutrition Program of the Government of India, WHO, UNICEF, USAID, BMG, PATH, led implementation of Anmol and he has led the establishment of technology-enabled health and wellness centers in inspirational districts and the demonstration of telemedicine HWCs in aspirational districts of UP, supported development and implementation of nutritional support initiative of the government of UP for technology for adherence monitoring of patients and certification for TB elimination. Currently, he is working as Deputy Director, Health Service Delivery and Human Resources for Health and is model for Chhattisgarh and Madhya Pradesh. Has been a team for Path Health System Strengthening and Tuberculosis Specialist, Policy and Client UNICEF, India Country Office, and as a public health consultant to the Office of the Health and Family Minister, Government of India. Kindly inaugurate anecdotes.
Good morning, everybody. Thank you for the overhyped introduction. You don't deserve it. And I'll start with the dignitaries on the dais, off the dais, and with people, all what's in the field. It becomes really intimidating to stand in front of August when people like it's difficult to start sessions. And so I my best to do justice to all that I know today. So, with that, I'd like to start presentation, which would be, I would just limit it to a talk and be very mindful of the time. So, the convergence in medicine actually be a day-to-day affair. There are no two departments that need to converge together, both in public health, in private practice, in education, and above all, in policy framing for patient safety, safeguarding the interests of the physicians, the care providers, and the facilities. I think that there are areas today which the ability to serve patients more effectively and provide the care they want, where affect how the healthcare ecosystem works. There are rights of the patients. That's the legal framework. Medical care, right to confidentiality, human dignity and privacy, right to no discrimination, right to safety and quality care according to standards, right to seek a redressal by patients, right to choose alternative treatment wherever they want, right to a second opinion, and right to transparency in rates and care. A doctor, the organization I work with right now, we work with how doctors respond. We also try to bring in efforts to streamline policies to meet the needs of providers. And the Clinical Establishment Act is one of those areas where we try to kind of convince people to get into, and the rights bill for health. But there are a lot of misunderstandings. There are a lot of challenges, pushbacks from both the sides. The interest is to come to terms with accepting that laws will be there, patients' rights are fine, but safeguarding the interests of the doctors, the providers is as important. And with that tightrope, I think the two faculties will have to work together so the best comes in the interest of the patient. There are, in the perspective of a care provider, there are laws and laws and laws which one has to deal with. I mean, if we talk of broad areas, there are laws governing the commissioning of hospitals. Many of you are going to go into that practice. Laws of governing the qualification of providers. There are laws the sale, storage of drugs, and laws governing the professional training. But then There are more than 100 kind of acts if you plan to open a private hospital in Uttar Pradesh today that you'll have to go through. That is where the convergence comes into place. I mean, right, starting from Urban Land Act to Atomic Energy Act to Indian electricity rules, etc., etc. I mean, I'm not the right person. Legal people here know much more than that. And then there are qualification laws. Best thing is they need overall. They are changing. We have the Allied Professionals Act just coming in, the NMC Act replacing the Medical Council Act, and whatnot. From starting, then there are laws governing management of patients. And that's act to the mental health. There was regarding safe storage drugs and safe medication from blood bank, drugs, cosmetics, permits, narcotics, psychotic substances, sales of goods, drugs, cosmetic rule, and adulteration act, negligent conduct. I mean, the law, the whole day can just pass by naming those laws. Governing employment and management of manpower, safety of patients, public staff within the hospital premises, radiation surveillance act, AR act endangering lift or patient personal safety. So, meaning thereby that we professional facility is being surrounded by an ocean of acts, laws, regulations, and whatever we call it. Now, there are laws governing medical legal license of a hospital can be as big a thing like facing one of the biggest corporate of his act is. You can just be lost in those laws. Convergence refers to merging of separate entities to create a single cohesive unit. It's not necessarily that they merge physically, they merge as a legal entity, but they need to come on board to converge. It refers to how public health combination of clinical practice with non-clinical fields and law being amongst the prime ones. We need convergence for health innovations based on interdisciplinary and team. Convergence medicine is moving towards pharmaceuticals, biotechnology, a lot of technology coming in today. I have had a little bit that I did during my UNICEF stint. There's telemedicine, there's mobile health applications, there's data analytics, electronic health records, and e-health. Wellness is another thing. Ma'am was mentioning that they has taken part in going to African frontiers. There are treatment from abroad. That's another industry. Legal and the medical sports, genetics and bioengineering. Health, legal framework and IT in new areas is again obsolete in many areas, needs an overall, and maybe needs a review. Health management policy of 22 is one of those examples. Telemedicine and practice guidelines. I think we were fortunate enough because of COVID that they and cosmetic acts which changed recently. The clinical adopted it, but the implementation looks far from real. The Assisted Reproductive Technology Act. So there are a lot of challenges because of these convergence with IT. There's an update and need for new policies and regulations, need for compliance with regulations. There are a lot of government funding for research in the as eager as it, and the grant funding panels not structured in a way that makes the telemedicine looks great, but the recent example of Sushant Singh's death, if you go to, clonazepam was prescribed, procured from telemedicine e-platform, and that came up for a drubbing by the court. So with new areas and innovations will come challenges, and many will be legal definitely. Pandemics brought another legal challenges. A day we were put into a lockdown, mentioning the Epidemic Act of 1897 and also Disaster Management Act of 2005. But we all know what happened. So there is a room for these laws to be examined. Thousands of migrant workers were just moving, and I mean, we know those stories. I don't want to go into it. Definitely has proved insufficient situation, and at times even ignored the rights of the citizens. Appropriate health emergency law could accommodate many demands with emerging new pandemics. So we have a new National Health Policy 2017, which talks of professionalism, integrity, and ethics, and it commits itself to a highest professional standards of ethics and integrity, supported by a credible, transparent, and responsible regulatory environment. It talks of an inclusive partnership or regulatory framework which will ask many of these things like clinical establishment, professional and technical education, safety, instruments. So, national health policy talks of professional education regulation, clinical trials, pricing of drugs, medical devices, and equipment. There is a first question that is one of the national health policy: whether to pass health rights bill or not. Health rights bill, we all agree, is the need of the hour, but are we ready for it? And how do we prepare ourselves for it? Whether the focus should be on what state enforces or what citizen demands of the state. Right to health without the basic health infrastructure like doctor-patient ratio, patient-bed ratio, nurses-patient ratio are of threshold levels, and are they equitably distributed? Do we have the same facilities as we have in Lucknow and Siddharthnagar? Can we compare the two? There are procedural guidelines, common regulatory platform for public and private sector standard protocols. Do we have them as standards already? Responsibilities and liabilities of insurers, clients, regulators, government in administrating the right of health need to be clearly spelled out. And so right now, though the NHP stopped at saying that it will be an incremental assurance-based approach, but we need to work towards rights, health rights bill. And I think the two faculties, the two minds that needs to converge are health and law. With the states being responsible for implementing health, is it okay to have it nationally? So one of the examples that is the Rajasthan Act 2022, which was brought up in March 2023. We have a learning from that. See, there was a clarity in the bill without what would count as an emergency, because a citizen could claim emergency treatment in any hospitals without paying anything. After the bill was put to public, there was a very valid hue and cry from the medical fraternity. Emergency was changed. There was a clause brought in reimbursement to private hospitals by government if the patient is unable. Then the hospitals were defined as only hospitals with 50 or more beds which come under the category or are a PPP model or have taken land from the government will come under the ambit. Medical professionals as public representatives and experts, that was accommodated. The example I cite is because what happened as a agitations, repercussions could have been better handled by society, collaboration, and they could have done a better job. And we have the area open. The other states are yet to get it. Rajasthan is yet to improve it. We can work together. Working together is the only way out. Are we ready to reassemble? That's the question. Because future health is too complex for a siloed approach. Actionable convergent concepts are upon us daily, whether we agree or we sleep on. Innovations are too rapid for our current care models and laws. And policy legislations and laws need to be wholesome in safeguarding interests of not just patients, but provider and the ecosystem. So there's a concept of medico-legal partnership where facilities together can and downstream to support the system. The healthcare part, MLP can support public health laws downstream. So it's not always a black process. Converge way forward. Thank you so much.
Obviously, the policy matters become a crucial factor. Health domain can't be a role of the officer legal in public health and in the health promotion WHO headquarters, Geneva, provides a technical assistance to WHO member states tobacco control issues, in particular plain packaging and regulation of novel and emerging nicotine and tobacco products. Kritika is the co-author of litigation relevant to regulation of novel and emerging nicotine and tobacco products, that analyzes 95 of novel and emerging policies. She has also updated the global status report on tobacco plain packaging, which provides technical details about the global implementation of plain packaging. For environmental perspectives, kindly connect with us.
And I extend to Dr. the overall touching studies request you to address by stating that I need to already look at abstract work and discussions that you will be undertaking in the next few days. Intervention as pushing your thinking and exploring how legal instruments used to promote health. Physical, mental, and really the absence of disease or infirmity. So what I'm going to talk to you about today is the potential of laws to prevent and control non-communicable diseases or NCDs. You would have all heard about someone in your family or community or neighbors suffering from heart disease, stroke, cancer, diabetes, or chronic lung diseases like asthma. In India alone, the burden of NCDs accounts for 66% of all deaths. But you may pause here and ask, what's the intersection between laws and NCDs? Well, NCDs are often influenced by a variety of risk factors. These include lifestyle choices and behaviors that increase the likelihood of developing NCDs, such as tobacco use, smoking and other forms of tobacco significantly increase the risk of various NCDs, including cardiovascular diseases, respiratory diseases, and cancer. Unhealthy diet, consuming a diet which is high in saturated fats, sugars, and salt, along with low intake of fruits, vegetables, and whole grains, is associated with an increased risk of obesity, diabetes, and physical inactivity. Lack of regular physical activity or exercise is significantly a risk factor for obesity, and also harmful use of alcohol. Excessive alcohol consumption is linked to liver diseases, cardiovascular diseases, cancer, and other health problems. And laws can be a powerful tool in the fight against NCDs by influencing people's choices and creating healthier environments. Here are a few examples. Discouraging unhealthy behavior. Now, laws can make unhealthy things less appealing. Think of high taxes on cigarettes and sugary drinks, which discourage people from buying them as much. Also consider smoking bans that protect people's right to health and shield them from secondhand smoke. Encouraging healthy behaviors, subsidies on healthy foods like fruits and vegetables can make them more affordable. While laws requiring schools to offer healthy lunches nudge kids towards better choices. Restricting unhealthy products. Some laws might limit the sale of unhealthy products to minors and even ban them altogether. Uh, Look at the legislation passed by the Indian government protecting youth from electronic cigarettes and heated tobacco products. And then labeling and marketing. Now, clear labeling on food packaging can help people make informed choices about what they eat. Laws restricting how unhealthy products are marketed, especially to children, can also make a difference. Let me give you an example. In Chile, they championed front of pack nutrition labels that specifically state the fat, sugar, and calories on a pack. No, it's not the nutrition labeling that we have in India where it's written in minute. They've got these big labels on the front of the pack. So mothers know exactly how much sugar there is in a cereal, how much fat there is in a bar of chocolate. And this is having huge impact on reducing the purchase of sugar-sweetened beverages and cereals in the country. The newest frontier is digital marketing of these health harmful products, where consumer behaviors are tracked and analyzed to tailor marketing strategies. This aspect underscores the importance of regulating how personal data and data of adolescents are used to target advertisements of these products, especially considering their potential impact on public health. Now, with these examples, it's important to acknowledge that India has excellent tobacco control laws. However, when it comes to other risk factors such as alcohol and unhealthy foods, we're slightly lagging behind. And these are not easy sectors to regulate, as the industry often challenges any intervention on grounds of freedom to trade in business, as not having enough scientific evidence to take on such a measure, and curtailing their fundamental rights. Now, I've noted some interesting abstracts that discuss the impact of environmental pollution on public health. I'm currently at an intergovernmental negotiation where countries are trying to negotiate a plastics treaty. However, with different stages of development, countries find it hard to agree on what the control measures of this should be. Plastics really are a result of complex chemistry, and some chemicals have been linked to NCDs and affecting fertility. But extremely emerging area of law, which it's an exciting time. It's not even emerging. I think there's so many aspects of constitutional law, data law, which all intersect when we talk about public health law and health law. So I extend my best wishes to all the participants for presenting their papers and engaging in a very healthy discussion. May you have a great time, and thank you once again for this invitation. I'll stop here. Thank you.
Thank you, Greta. And obviously, it's a matter of pride when your own students are holding such prominent positions in such prominent places. Shikhar Ranjan sir, the guest of honor of the international conference, is a public health specialist, a medical doctor by training with an MD in community medicine, having experience of 16 years working at district, state, and the national level. He has an in depth expertise in health policy and advocacy, project leadership, private public partnership, digital health, health innovations, pragmatic strategy development. Sir, Sir is an apt person who would be talking upon the convergence of health being an LLM from the Delhi University in 2019, along being the doctor for this in medical field as well. So kindly make the deliberation for the inaugural address.
Good morning, everyone. Ma'am, thank you very much for your kind words introduction, but let me make it very clear. I'm not a medical doctor. I am a lawyer, like many of you law students who are sitting here. I did my LLB from Lucknow University and have been working with the Medical Council of India, the apex medical regulatory body, for a decade. I worked with them for a decade, and that is where I learned the dynamics between law and medicine and policy. So, with this clarification, I would like now to take this opportunity to begin my address. The distinguished Chancellor of this university, Professor Syed Wasim Akhtar Sahab, the Pro-Chancellor, Dr. Syed Reem Akhtar Sahab, the VC, Professor Javed Musharraf Sahab, the respected Dean, Professor Syed Wasim Akhtar, my learned teacher, legal luminary, Professor Ved Kumari, Professor Abha, and the dignitaries on the dais and off the dais, as well as the eminent panelists and scholars who are present. It is my distinguished honor and privilege to deliver a special address in an event which is jointly convened by Faculty of Law and Faculty of Medicine of your esteemed university. Let me begin with this proposition: the discipline of law and medicine are perhaps as old as the society itself. No society, we all know, can exist without certain norms, and we as human beings do fall prey to disease and need medication to cure. Medicine is generally meant as the art or science of prevention and cure of diseases. The profession of physician is considered to be as old as the history of mankind itself. And the journey of medicine has moved from mysticism and spiritual belief to, in the last 2 centuries, to modern medicine. The last 200 years, it is said, the relationship between humanity and the environment has changed forever since the Industrial Revolution. And in the field of medicine, it is very much evident that with the discovery of penicillin, antibiotics, widespread use of vaccines, invention of modern diagnostic techniques, organ transplant, etc., as well as use of artificial intelligence in healthcare, robotic surgery, etc., that is all taking place. This relationship between law and medicine is rapidly changing, evolving, and shaping. Hospitals, which for
decades ago were a dreaded place to go are now the place of care and healing, giving hope to the humanity. And in this last 200 years, human lifespan has significantly increased. In fact, mortality has considerably declined. Now, let me come to what I want to discuss with you all, talk about. My association with the digital governance system of the nation commenced in 2011 when I got an opportunity to serve the Medical Council of India, the erstwhile Medical Council of India, known more by its acronym MCI. Those of you who are doctors, budding doctors, would know more of it. I will take this opportunity to inform the lawyers or budding lawyers here to tell you about something more about it. So when I joined this organization, the dynamic relationship that exists between law and medicine came to my understanding. And as a lawyer, I got to play the role of legal draftsman and educate, briefing the councils in the litigation that MCI faced, and in several other aspects in day-to-day governance of the MCI. One such activity was ensuring the free flow of information under the Right to Information Act, which promotes transparency and accountability. My previous learned speaker mentioned that there are ocean of laws governing the medical profession. A compilation of a compilation of enactments brought out by a private publisher include 26 civil legislations on this aspect. And let me also tell you here, our relationship with healthcare professionals or doctors start from the moment a child is conceived in mother's womb. It is a midwife or a healthcare professional that monitors the health of the child in the womb. And when the child is born, it is the doctor who certifies the time of birth, the gender of the child. And finally, when we depart from this world, it is the certificate doctor that is required to cremate or burn the body. The relationship starts from who to do. So that is the aspect we need to remember. Coming back further, going back further, among the higher education streams, based upon my experience with the Medical Council of India, I can tell you that it is one of those systems of education which is governed by a maximum number of legislations, both primary and secondary. There is a cobweb of regulations, procedures that are in place. Therefore, it is very timely that two faculty, law and medicine, have united to organize this conference. Ladies and gentlemen, allow me to address some of the key issues that you might consider to you are relevant for healthcare governance in this country. The first such issue is what I say, the recognition of the system of medicine. Not everyone is entitled to treat a fellow human being. Only those who possess sufficient learning skills within under a master are allowed by the sovereign to practice the art and science of healing a sick fellow human being. We all know the concept of Rajvair or Shahiyaki that was going in vogue in our tradition. Legislative recognition to the system, Indian system of medicine, that means the Ashtanga, Ayurveda, Unani, Siddha, and Soma Rigpa systems of medicine came to be accorded only in 1970. Presently, it is regulated by the National Commission for Indian System of Medicine Act of 2020. Homeopathic system of medicine got recognition in 1973, and as of now, it is regulated by the National Commission for Homeopathy. The most common system of present day modern medicine is modern medicine, and it is this system with which I had worked. And this system got recognition as early as 1940 with the enactment of the Bengal Medical Council Act. Presently, it is the National Medical Commission Act of 2019 that regulates the profession of medicine. Now, why I'm telling you about this? Because herein lies the key. Your right to be treated as a patient is a crucial right. This right gives you the right to be treated by a system of medicine of your own choice. You can go to a Hakim, you can go to a homeopath, you can go to a modern medicine practitioner. The state cannot tell you to choose a particular system of medicine. So that is where it is crucial. Here, in another detail that is live is that only those who are holding qualifications in these streams and are enrolled with their respective councils can practice the system of medicine. Another aspect is that a homeopath or a allopathic practitioner cannot give you a medicine from a different stream. Ayurvedic cannot give you allopathic medicine, or allopath cannot give you Ayurvedic medicine. So, osteopathy is not permissible in law, and the apex court in Poonam Verma versus Ashwin Patel, a case that dates back to 1996, held that, and I quote, a person who does not have knowledge of a particular system of medicine but practicing that system is acquired and a mere pretender to medical knowledge or skill, or to put it differently, charlatan. This aspect, as I mentioned, is crucially linked to healthcare, and that ought to be affordable, available, accessible, and we should be aware about it. Now, very often we come across terms like acupressure, acupuncture, Chinese system of medicine, electrohomeopathy. These are recognized by law. Law would remember law is the command of sovereign. So the legislature, wished for us as sovereign, does not recognize these systems of medicine, which would mean neither the practitioner nor the patient would have any right. A bill titled as recognition of new system of medicine bill was moved by the central government, but it never got beyond the corridors of central secretariat. Now, let me move to what is the most dominant of all the systems of medicine, both globally and locally, modern medicine or Western system of medicine. You have a campus of, within your university, Integral Institute of Medical Sciences and Research. The dean is sitting next to me. This system of medicine, your teachers would have taught, those of you who are doctors, had its origin in 3rd millennium BC in Egypt. In India, this part is interesting. In India, it came primarily through the European traders in the 15th and 16th century who came here in search of black pepper and other spices. And interestingly, black pepper, being the most best known natural preservative, was crucial to preserving food in the cold climate of Western Europe. And in those days, it was traded against gold from Kerala coast. So therefore, you find the maximum amount of gold in a place called Thrissur in the Kerala. They got gold from Westerners and sold their pepper. So that black pepper story is very interesting. And with their trading ships also came something called ship doctors to treat those who fell sick on board. This system of medicine, modern system of medicine, came to our shores through these ship doctors. And now again you will see one such ship doctor successfully treated a Mughal princess of her severe burns. In return, the Farman of the Mughal emperor, the command of the sovereign, gave them not only the right to trade in India, but also the right to practice Western system of medicine. So the history of colonialism is intrinsically linked with the practice of medicine in this country also. The British East India Company established way back in 1764 the Indian Medical Service. This service dates back, is much prior to the creation of the Imperial Civil Service or Imperial Police Service. Subsequently, the British government laid down a plan to fill the position of native doctors in the civil and military establishment of the presidency of Bengal. So there were white doctors to treat white people, and there were brown doctors to treat we the brown people, the colored people. So a type of racism existed during the colonial period in the practice of medicine, white doctors versus brown doctors. Subsequently, the British decided that there ought to be a native medical institution in 1833. committee proposed for education, and the first medical college got to be established by Medical College, Calcutta on 28th January 1835. Its purpose was to train native youth irrespective of caste and creed. The admission of these students was through a tough competitive examination. Most of you who have come through NEET would know that only 20 out of 100 got selected for the first batch, and subsequently, this is the oldest medical college in the country. Subsequently, colleges came to be established in the towns of Bombay and Madras, and Portuguese who were occupying Goa, they established a college which was known as Escola Medico da Goa. They claim it to be the oldest medical college imparting education in modern medicine in Asia. Our own KGMC in this city came to be founded in 1906. Legislative recognition, as I mentioned, came in with the Bengal Medical Act of 1940. It is interesting to note the definition of medicine in this act. Medicine is defined to mean modern scientific medicine and includes surgery and obstetrics, but does not include veterinary medicine or veterinary surgery or the homeopathic, the Ayurvedic or the Unani system of medicine. Suffice it to mention here itself, in the NMC Act of 2019 or the Indian Medical Council Act of 1933 or 1956, same definition is there. Another important piece of legislation that is relevant for our purpose here is the Indian Medical Degrees Act of 1960. This is the act that made practice by a person not holding scheduled qualification a criminal offense, and this provision subsequently was included in the Indian Medical Council Act of 1933. So if you don't have a qualification, you cannot practice, and your act is recognized as quackery. 1933 is said to be the first step in which the system of recognition of qualification and constitution of Medical Council of India takes place for the first time. Subsequently, in 1946, the kind of health governance system that we have, in which we have primary, secondary, and tertiary care system, and the concept of basic doctor and the delivery of healthcare system through these mechanisms, was given after a decade-long work by a committee called Bhor Committee, which was headed by the then Surgeon General of India. It also led to enactment of the All India Institute of Medical Sciences Act of 1956, as well as the Indian Medical Council Act of 2019. The IMC Act came to be replaced on 25th September 2020, and now NMC is the apex medical regulator. Let me also clarify here, I am no longer associated with NMC. I was part of the Medical Council of India. Now, a key feature of the new regulatory structure in all these three systems of medicines is that there are, apart from the commission, there are regulatory 4 autonomous boards that are set up to regulate undergraduate, postgraduate, ethical aspect, and the medical assessment and rating aspect. So this is how, through a commission at the apex level and 4 autonomous boards, the permissions and continuance of education is there. Suffice it to say that every aspect of your medical institution, whichever stream it may be, from life to if it is to be closed, is governed by some or other piece of regulation or delegated legislation. Those who are studying undergraduate MBBS, there is something called regulations on graduate medical education. So that governs your law. And surprisingly, interestingly rather, law always is shaped by political forces. Politics plays a crucial role in the shaping of law. I had a brief conversation with the distinguished Pro-Chancellor. So, MCI is known for its inspection regime. Way back in 1990, the then Chief Minister of the state of Andhra Pradesh went on an opening spree of medical institutions in every part of his state, and that ruffled feathers at the center because center wanted to exercise greater control over it, and The government at that time was headed by another starting of a medical college or increase of seat or opening of a postgraduate course or postgraduate seats was made subject to grant of permission by central government on the recommendation of the Medical Council of India. But quite significantly, this act gave another important right, and this right was right to open new medical colleges by private entities. A society, a trust, and later company could also open a medical college. This gray area which was there, which was filled by this, and the amendment made in 1992 paved the way. At that point of time, if I recall correctly, there were not more than 200 medical colleges in 1992, and as on date, we have 700 plus medical colleges with 1 lakh students being studied. MBBS students are nearly 60 to 75, 65 to 70,000 postgraduate seats, which are there. And all this aspect shows you a critical relationship between law and medicine. The doctors tell us this is what we need, and as lawyers we craft that the shape in it in the language of law. Another significant aspect that I had personally occasion to deal with was relates to the common entrance test. The MCI regulations since 1997 provided for entrance through a common entrance test. There were hundreds of such exams that made aspirant appear in multiple exams at great efforts. There was menace of capitation fee also. So in 2009, a committee of MCI decided that there should be a nationwide one entrance examination based on the principle of one nation, one merit, one exam. And the legislation that we made was delegated legislation that we made was immediately subjected to more than 100 writ petitions in different high court. And interestingly, while one of the petitions was being heard in Supreme Court, the Supreme Court judge presiding over the matter, Justice Dalveer Bhandari, who presently sits in the International Court of Justice, he advised us in the open courtroom that why don't you get these petitions, all petitions pending in High Court, transferred to Supreme Court and get the matter decided here in the Supreme Court by us. Late Chief Justice Altamash Kabir, on 18th July 2013, when he demitted the office, he gave a verdict in which he declared that need to be unconstitutional on various grounds, including that it impinged upon the right of minority educational institution to administer their own educational institution. The dissenting judge, Justice Anil Dave, held the law to be constitutional and in national interest. Both the Union of India and MCI immediately filed review petitions seeking recall of that judgment. On 11th April 2016, a three-judge bench headed by Justice Dave allows the review petition issues direction for holding NEET that very year. A month later, on 24th May 2016, the central government amends the Indian Medical Council Act and the Indian Dentistry Act to include a provision whereby admission to undergraduate and postgraduate level in medical colleges has to be through a common entrance uniform entrance examination. This uniform entrance examination is now part of all the law dealing with medicine streams as well as nursing and pharmacy admission is happening through NEET at the undergraduate level. Undergraduate level. To an extent, I can share this information with you. The NEET has proved to be student-friendly measure, and to a great extent, it has also helped in curbing the menace of capitation fee in the admission process. Another important reform that is ongoing is the online counseling that takes place through this process. Efforts are to make
that online counseling also one for the entire nation, one. So a student will have to just fill a form, one form for entrance and one form for counseling, no running around the state, every state. Now, the last aspect that I would like to talk to you about is relates to telemedicine, which was mentioned by my previous speaker. 24th March 2020 is a day which we all remember because on that day the Prime Minister announced nationwide lockdown. We were sitting in MCI office and immediately we were told to come up with something which would help in delivery of at least clinical advice during these crucial times. The nation was having 21 days of lockdown. A draft telemedicine practice guidelines was in place. A judgment by Bombay High Court has declared the practice of telemedicine as unlawful because it said that clinical exercise can only be on the basis of physical examination of a patient. You cannot deliver or prescribe medicine based upon consultation on telephone. So we came up with something called telemedicine practice guideline, and that's what it immediately placed in on the MCI website the next day. Later, we all know telemedicine became a multi-billion-dollar industry, which is now acceptable to both medical professionals and patients. Lastly, let me, to conclude, say that as a legal profession, my journey in learning and understanding the various facets of the dynamics between law and medicine has been fascinating. Both law and medicine are demanding professions with high ethical values, and each of these issues that I did talk to you about are crucial, transformative, and demonstrate a close interplay of law and politics. I also once again thank the organizer for the generous hospitality in giving me this opportunity to share my views. Thank you very much.
Thank you, sir. Your immense experience in the field of law and pertaining to the Medical Council of India, we would be availing it in the technical sessions as well. रौनके बज़्म नहीं था कोई तुझसे पहले, रौनके बज़्म नहीं था कोई तुझसे पहले, रौनके बज़्म तेरे बाद नहीं है कोई. Professor Ved Kumari, ma'am, Vice Chancellor, National Law University, Odisha. Ma'am has been a former Dean and Head Faculty of Law, University of Delhi as well. She has been teaching in law since 1983, and she has also been taking the courses, graduate and undergraduate courses in the University of Delhi, Jammu University, and Vanderbilt University, USA, supervised LLM dissertations and PhD thesis. She is the Fellow of Commonwealth Judicial Education Institute, Canada, 2010, Commonwealth Fellow at Warwick University, UK, 1998, Fulbright Fellow at Vanderbilt University, USA, 1997. She has spent almost an year in Russia during research on the law and advocacy in relation to children in Russia as part of her sabbatical leave. She has been a great contributor in the field of juvenile justice in India. It is because of her recommendations that the various Juvenile Justice Amendment Bill has been amended and modified the definition of including the leftover offences within the ambit of the serious offences as suggested by her. Ma'am, we are the meager people in the field of law in front of you, and in spite of your ill health, you have bestowed us by your kind presence. I would request, ma'am, to deliver the inaugural address of the international conference.
Good morning, good afternoon, I don't know what time it is, whatever. So namaste. आप लोग हैं क्या? Anybody who has not seen a doctor till date? कोई तो नहीं है ना? So this is also as prevalent as law is. And for me, I was trying to get away from not coming here. Say, मुझे तो public health law आता नहीं है. This is not the area of my work. But your professor is very persistent. Just you have to come, so I am here. And I think in a lighter vein that I'm actually the convergence of medicine and law. I've been in the field of law since 1975 when I joined LLB. And I have seen so many illnesses, accidents, and I've survived because of medicine. So I think I'm the living example of convergence of medicine and law. But for the medical help, I would not have survived, and certainly law is what has given me my livelihood. But that's not what I'm going to talk about in my presentation. But I think when she insisted that I must come and speak, and this is an area I told, confessing to all of you, that is not an area of my work, but gender is an area of my work. So I thought, okay, let's examine it from the gender angle, because law also we keep on talking about gender neutral terms, and since the session began, we are all talking gender neutral as if human beings for whom medicine and law are gendered, they're not gendered beings. And I think that's something which has concerned me quite a bit, and I share some of these aspects. So first of all, these definitions, we have to be very clear. There's three. For me, health, when it comes to vaccination, there's a role in ensuring health in the vaccination. But after that, apart from vaccination, medicine is antithesis to health. If you are healthy, you don't need medicine. But even if you are healthy, you still need law. So law is something you can't escape. But if you have got your vaccinations and you are not ill or don't have an accident, you can survive without medication, even though most of us, all of us actually, I didn't see one hand also saying that you've never dealt with medicines and so on. But I think the important point for me in laws we started examining, when we are talking about human body, human beings, what is the human, because medicine and law, both of them are actually concerned with human bodies quite a bit. Law, of course, is concerned with a lot more than human bodies. We're concerned with environment, we're concerned with everything in the world, airspace and everything. But law, the medicine has to deal with human bodies. And human bodies are different. But when we think about medication, when we think about standards, law certainly did not think that women existed as a separate unit of human beings. They were submerged. But English language also says he includes she, man includes woman. Even though the terminology, the language, the words, actually woman includes man and she includes he. But literature people tell us that no, man includes woman and he includes she. So given that environment, certainly it's no surprise that every discipline of knowledge, whether it is anything else, it is all gendered. But are we paying attention? We do know, I was looking at the number of women in this room, and certainly on the panel there are many, much men, but not fewer. But every single girl, every single student who came to give us these bouquets was women. We do it so naturally that there are certain things which women do, certain things which men do, and it is all pervading. I recently was in a hospital with a broken nail issue. I'm the vice chancellor, and this doctor knows that I'm the vice chancellor. I have the illness, I have a problem, and he's talking my assistant as to what is the madam's problem. Are bhai, main bhi to hu. So how many times the doctors talk to the men, especially in the area when they're talking about, so for me, human body is the starting point, that in law, the human body, the human being we're talking about usually, and I won't have time to speak about that today, but you can have a look at some of the on the web, I think there is a lecture from me which says law is male. You can do the search and look at that aspect of it. So we are talking about that when doctors talk about humans, are they talking about which bodies? Certainly for certain purposes, they need to recognize women body as women bodies, because pregnancy is not something which men have. Pregnancy is, the menstruation is something which men don't have. So there are some things which men don't have and they have to focus on that. But when they deal with patients, especially in the area when we are talking about domestic violence, women are disproportionately subject to domestic violence. and they suffer injuries when they come to the doctors. The client confidentiality. Does it mean they will talk only to the woman, or they will talk to the husband to find out how did she get this injury? So there are lots of issues there, so I would want to focus on that. So what is the human body when we are talking about illnesses? At the most, what I'm aware of is that medical science is aware of the human body as male and female. So when a child is born not fitting of the two, they assign sex. They assign sex. We have standards. Whenever I get a lab test, it says for male, this is the standard right parameters, and this is for the females. What about the trans standards? Are they human beings? Are they concerned? How have we set up those standards? And also, I'm told that in Asia, 9 hemoglobin is not seen as anemic. In the West, it is 11. So how do we decide the parameters? Are these by reference to race, gender, location? So there are lots of things which are happening. Human being is a universal, global, the world over the same human beings exist, but in the medical field, same human beings don't exist all over. So there are some human beings which didn't exist in law earlier, now they have started to exist in the trans. I think in the medical field, they exist only to the extent of reassignment surgery. But in terms of parameters, they still don't exist. So I wanted to flag that in this particular one. Okay, here's my cue. So then, is health a norm or an exception? For me, it is an exception. I do not know for how many of you, but if you look at the data relating to these various things, I've just listed few. If you combine all of them together, and Professor Bakshi, my mentor and my guide and my professor, keeps on saying that in India, certainly health is an exception, being unwell is the norm. And this unwellness can be for various reasons, not only because of certain diseases. Mental health has certainly, I know that it was supposed to be world over, 1 in 4 of us has a mental health issue. And after COVID, it is 1 in 2. So certainly this is only one of the things which creates problem for the body. There are a lot many others. You can imagine the importance of medicine in our lives. Okay. So one of the good news, I work in the area of women, gender justice, and in the area of children. So certainly I know that this is the good news part of it, that IMR has decreased, but what hasn't is the nutritional status. And that is a huge concern both for women and for children. 1/3 of malnutrition children in the world exist in India. So I certainly think that there is lots needs to be done on that front. Then another aspect which really worries me is the commercialization of health. And when I'm talking in health, I'm using it in distinction from medicine. So health is the preventive category where you don't need medication. I'm talking about that. So certainly the health product advertisements are very gendered also. So one is the health means now take natural food, take natural medication, natural everything. And how much actually it is certified, no? When we were talking about the nutrition value. Now we have recently some cases come in which the nutrition values written is much less, the sugar indicators are much less than the actual one. So one does not know, even when the law requires certain declarations, how far these are true. And when we look at gender responsibility of keeping family healthy, who are the ones? Women, oil, you name it. Everything has to be the whole family responsibility of ensuring children's growth, children's wealth, husband's health, everything is the woman's responsibility. So we keep on reinforcing what women are supposed to do. The natural food and natural supplements have now become the in thing that you should not take artificial things. I'm allergic to lots of medications. And so supplements now, doctors prescribe me natural supplements. And if I say, no, I've got a reaction, no, you don't natural. We have allergies to natural products also. People are allergic to milk, people are allergic to egg, people are allergic to lots of things. So just because it is coming from natural thing does not necessarily mean that I should not be allergic to it, but I'm dealing with that. So for me, my whole life story is I've dealt with many accidents, I've dealt with cancer, I've dealt with, you name it, and I have had it in my life. And I'm happy that we have the medical developments taking place and researches, but also the pitfalls also as a consumer of medication I have dealt with. So targeting children is a major concern. I mean, just said ban foods which are not healthy. Chocolates. Now every advertisement says, let's celebrate festival chocolate. I mean, chocolate is your major problem with the teeth. And children have it very much. I mean, in our childhood, we had sweets, other sweets, but not those ones which are sticking to our gums. But now we have sweets which stick to the gum, and then, so we create clients by allowing this kind of thing. And this is, most of this is coming from ChatGPT, this particular slide. Because I said I do not know anything from where to start, so I used ChatGPT, and these are the headings which came. And I thought some of these are very important points which have to be highlighted. And when we look at, certainly malpractice is something which lots of people are now worried about, unnecessary tests being prescribed. When I grew in a family of doctors, my father was an Ayurved, my brother is a BIMS. So he did his Unani, allopathic and Ayurvedic. And we had a neighbor who had an homeopath. And we were very clear as we were growing up that all the three systems or four systems were very useful. And we were very clear if it is pain, etc., you go to the homeopath. If it is cough and cold, you go to my father for, he used to give very tasty churans and tablets. And if I need an immediate relief, I go to my brother. So for me, I have grown up in a multiple doctors' disciplines. But my father never asked for any test. He would just look at the nubs and will be able to tell. Nowadays, one of the malpractices a lot of people complained about is that unnecessary tests are prescribed. And I find it very, because I'm kind of so used to my father looking at nubs and diagnosing everything, that I find it very strange that nowadays, even if I go to an Ayurved, they'll say, hey, test karalo. They will not touch my body and they will give a diagnosis. I think you can go. That's why I know a personal kind of prejudice for that, for maybe coming from the experience. Then certainly the accessibility, healthcare access and equity, different sets of people. Now more and more private hospitals are coming up, and the government hospitals are so overcrowded that everybody doesn't have access to medication. When you were hearing about access to health, Right to Health Act, Right to Medication Act. Right to health तो नहीं है ना. It's only free medication, support medication, whatever. Because health is a much bigger category than medication, and in the name of health, we are actually only talking medication. Because health will require a lot more other things than what the law provides for. And certainly with my long exposure to doctors and medication and preventive and all kinds of things, malpractice, not malpractice, but negligence has been some of the things you do experience. I had a very severe drug reaction, Steven Johnson, and I kept complaining to the doctor that I'm not feeling well, I'm not feeling, no, nothing. So twice I had the exact symptom of the medication. I had a skin problem, because of which he gave me Dapsone, which is depressive medication. And then I had this severe reaction. Doctor refused to listen. So I think one of the things is the negligence, not listening to the person. We do it in the law profession also. We have dealt with 15 cases of divorce. Of 16th woman or man comes in and says, "समझ आ गया क्या problem है." So something I think somewhere that human relationship and the problem of negligence by not listening to the people or not paying attention to what is being done is something we do talk about. I skip the other aspects, but I think I would want to flag two aspects on the issues. One is the transgender person's issue, the other is the woman's issues. And some of these are common for women as well. But when it comes to the transgender, certainly in terms of parameters, they don't exist. They exist in the medical profession only when they need some therapy for their what is it called? Dyspora. No. The confusion about their sexual, their gendered identity. And initially, even the sexual identity was seen as a mental illness. And I think somewhere in 70s we declared it's not a mental illness. But till date, we do know a lot of people still believe that same-sex preference is a mental illness and it's not a natural condition. So somewhere the medical profession has also to look at this gender aspect, that how do we consider that what is natural in the human body and what is not natural. Whether the transgender body is a natural body, trans person, whether it is transsexual or whether it is asexual or whatever are the abnormality we declare, why is that an abnormality? Just because majority is like that? So why do we not recognize any person having different kind of reproductive organs as also a normal natural body? Because nature is full of variety. Everything is natural. Everything which grows is natural. So new species come out of pollination. So lots of things in the nature, diversity is the name of nature and nature is natural. And therefore, if there is any variation in the human body, that's also natural. It's not human-made. So anything which is human-made for me is not natural, but everything given by the nature, the conception happened by the natural process, the childbirth, the growth in the fetus happened by the same natural process, the birth was by the same natural process. So how come the outcome of that process is not a natural body? So I think somewhere the very recognition, certainly law had taken a long time. I do not know where which extent the medical field is there. Intersectionality becomes more difficult if it is a minority, and illiterate, all kinds of further vulnerabilities are added and that leads to a problem. Then some of the women's issues I wanted to flag. You can see some of those are similar. When we talk about sexual harassment at workplace, certainly a lot of transgender person when they get to the workforce, including a vice chancellor who was the third gender vice chancellor, had to leave pretty quickly. So there is certainly a lot more challenge for the transgender people in the workplaces, but women are equally vulnerable. And it was the women's issue in Vishakha which got first time recognized that because of the discrimination at the workplace, they have to face a lot of sexual violence, quid pro quo, uncomfortable environment, and also sometimes leave their jobs, suffer mental illness because of that. Parental leave and work life. All aware of childcare leave? Childcare leave available to women up to 2 years till the child becomes 18 years of age. Doctors included. So male doctor doesn't get any childcare leave. They're not burdened by the state to take childcare leave. So men, all men, including doctors, male doctors, discharge their responsibility of childcare by taking 15 days of paternity leave. Only that. Their lives of their children, they discharge their responsibility as important fathers. But women, by law, have been given this responsibility of looking after their children, whether it is illness, whether it is PTA, whatever it is, whatever responsibility. So not only the parental leave, but also the elderly leave, elderly care. It's all on the women. So whether medical profession is one which requires actually 24/7 duties. And therefore, it is a very, very difficult arena for women doctors to make this balance in their lives. Reproductive health is another very, very important area because of the health issues again. And I'll move, okay, so this is some of the burden of reproductive health, not reproductive in terms of containing the family size, is on women. Women's sterilization, look at the percentages. So this data is indicating National Family Health Survey This is 5 on the left side. This is 4. And the first figure is rural, then urban, then total, and this is also total. So you can see that the men have barely no burden in family planning. It is the women's body which have to be cut or used. All the contraceptives are women oriented. They have to take tablets and then take the side effects. So the whole arena is very gendered, while both of them are required for reproduction, but the burden to control or do whatever is a lot more on the women. I recently attended this webinar by UNICEF in Nepal, and it was on maternal anemia in South Asia. And I thought this research presented by this doctor was very interesting. I'll share a couple of slides for her. So she gave us this figure. Each year, 210 million pregnancies. This is a study she has conducted in 19 hospitals in India. The study is, of course, coming from UK, but she is from Assam, a researcher there, and doing this. And childbirth can actually mean death in many cases. This is our SDG goal is in 2030, we should have less than 75. Presently, we are at 97 in 2018-20. So certainly childbirth continues, which is exclusively a woman's burden. That actually reminds me of the convergence we're talking about. We went in US and UK to an exhibition of drawings done by artists to educate doctors in very, very old era when we did not have photography. So what they used to do was to, when they will do the dissections of the bodies and at different layers, they will draw how the body looked like. And then we came back with our law faculty, law school teachers were gone there. So coming back, they asked us the question, what are the legal issues here? What are the legal aspects of this drawing that we saw there? So one of the questions we asked was that who has ownership over the dead body? But there were lots of prisoners who were executed and their bodies were dissected to get that. Then we also noticed that woman body, all the women bodies which were presented in the drawings had a womb and a baby in there. So whether a woman body can exist without a womb, whether a woman continues to be a woman if she doesn't have a womb or it has, hysterectomy has happened. So those are the kind of questions which emerged. But certainly this is a real life story of the women, and we still have very high maternal mortality. And what this research pointed out was the anemia is a huge category. We do have some figures, I think, of on anemia. When you look at this state of anemic condition, this research makes a lot of sense to me, because when you look at this slide, she said that incidence of 1 in 250 acute heart failure in pregnant women does happen, and this is the information. What she found out was that doctors usually, if there is a patient who is anemic, some of them do not respond to it. And then she was looking at that if in an anemic woman who has not responded to medication, induced birth is given, then in how many cases the possibility of postpartum hemorrhage is there, it is very high. And I think she was making a very important point. Some of you may want to look at. So maybe, and the doctors already know this, but for me this was all new information. And connecting it to the anemic level of women, the high mortality rate, and also the burden they have to carry, the double or triple burden of family care, or jobs, etc. they have to do, is such a very onerous journey, which also leads to lots of other medical complications. This is a suggestion that we must give very clear guidelines should be created. Some other couple of critical thought issues, I think. One is the issue of abortion, which is again a woman issue. One of the conditions for permitting abortion is failure of contraceptive. I've never understood how do these doctors determine that. I mean, this is something between the couple. So whether it is used just as a measure to get that adoption. Then also I think a lot of people believe that it is a right, but in India it's still not a right, it's a permission, and it has a time frame which is now being challenged in a number of cases, either because the child's abnormality was discovered at a later stage, or because the pregnancy was discovered at a later, especially in rape victims. But this is kind of leading to another question, that if the fetus has become viable with all the support that medical support and the medical inventions we have, fetus at a very young age can survive in an incubator. And therefore, whether if the child has a feasibility of survival, can we still allow that? I think that's another issue which is coming up. Doctors, now we have made a change in the law by saying that whether married or unmarried woman, irrespective of status of being a married or unmarried woman, she can seek. Previously, it was only the married woman who could seek abortion. So very categorically, pregnancy was linked with marriage. But we do know that children are conceived not by marriage, but by sexual activity, which can happen without marriage also. But the general practice has been always to ask the husbands, if she's a married woman and she wants a product, she needs an abortion, husband's permission. From where does it come? And this is an example of more instances to come where if she is a married woman, her status as an independent, thinking, adult human being is not recognized, and it is always the husband's permission which restricts her area of operation. This is another area where pregnancy is very young girls, 12, 13-year-old subjected to rape are ending up in this state, and there sometimes a lot of issues there also about whether to permit there's this whole thing about whether abortion is a sin or it is a normal activity of human development. And this whole concept of abortion is a sin leads a lot of even child welfare committees to insist that this woman who has at the age of 13 or 14 or 12 has conceived a baby should not abort, should give it in for adoption, because it's not right to do that. But I think we need to keep our conceptions of sins or rightful activities to individuals, and especially in this arena. This is another controversial area. Law has permitted abortion of a fetus which has a severe abnormality. In the medical profession, I'm aware that even with minor abnormalities, doctors do suggest abnormality hai, abort kar do, when it's permitted. I think that's also leading to the disability rights. People have got two objections. One, how do you define severe abnormality, which prevents a person to enjoy the ordinary normal life. I was talking to a person who was born with mental, not physical illness, I think, what do you call it? Atrophy. I forget now the other term. So he's been since his birth on the wheelchair. Just how to define normal life from enjoying it. So somewhere the disability rights people are in challenge of this abnormality. And so one is that if you become a disabled person after birth, then you are not worthy of living, because you are saying even before birth you can be aborted, you can be just destroyed. So therefore, worth of human beings is determined by reference to ability or disability as we define that, and our conceptions of. So certainly there is a problem in the way the medical people and the law people have come together to deny an honorable existence to people with disability. Feticide is another one which is huge problem. How many of you think educated women are aborting female fetuses? Educated women are aborting female fetuses. Nobody? You'll be shocked. So this is from 19, which year to which year is this? country? 81 to 2011. You might think, okay, it was going down, but now that we have become the 21st century, we are all educated, we are all good, but that's not the case. This is again from the earlier point, but this is the figure on educated women. Graduate and above are slowly slightly better than middle but below graduate mothers. Look at the uneducated. So who are the ones who are responsible for child sex ratio? Why do we have such huge child sex ratio? It is the doctors, it is the parents combined. The unborn child doesn't have a say. It cannot happen without a collusion of law, not law, the social practice and the parties involved. Parties involved are doctors and the. I heard of practices like सब कुछ ठीक है, लक्ष्मी आएगी घर में. लक्ष्मी आएगी, लक्ष्मी नहीं आएगी. आप लक्ष्मी नहीं, आप वेडनेसडे को रिपोर्ट लेने आ जाना. आप थर्सडे को आ जाना. इंडिकेशन कि थर्सडे को सारी मेल वाली रिपोर्ट मिलती है, वेडनेसडे को सारी फीमेल वाली रिपोर्ट मिलती है. अरे सब ठीक ठाक है, बर्फी खिलाइए, लड़की होगी. अरे लड्डू बांटिए, सब ठीक ठाक है, लड़का होगा. There's so many dubious practices the medical professionals have adopted, and despite the legal regulation, it doesn't change. So I don't think law is the panacea for convergence of health. It's only one of the tools. Our social practices thinking is an important factor which is regulating both law and medicine. And I think we need to recognize that very categorically. Okay, I did something wrong. So 91 to 2001, look at the rural and urban area. We think we're educated, we are well off, we can afford daughters, but no. Because we're educated, we don't want to have more than two, but we do want to have son. So therefore abort. I've talked to any number of women from educated families who will say that no, there is no direct taunt on us if we don't have a son, but indirectly the hota there is a lot of pressure. And of course, because we do not want to have, we're not like our maids now who will have 5 daughters in the wait of son, so we will abort the female fetus. It's happening with the connivance of the human beings and the practice, the thinking, the son preference we have. It continues to be so even today. The same thing, 1924, urban, 931, rural, total 922. It's better than the last one because earlier we had 919. But when you look at the details, what are the cities and which are the states? Haryana was one at one point of time the first in the country, but it is not so today. These green ones shows the improvement. This is not very significant, but still improvement. But look at the other ones. All the yellow ones are the ones, the states which have the number still going down, and we are talking about NH 2019 to 21. So it's not that today we have become enlightened and we are no more aborting female fetuses. We are continuing to do that. And legal profession and law has to take cognizance of this trend. And this is across the country. Look at this one, even Kerala, 100% literacy rate. The number has gone drastically from 1047 to 951. The states which have done very well. What is that state? The first one yellow, not the green. So these two, when you look at, they are doing better than a lot of others. So I don't, and it's kind of across the country that we're saying that. Tripura, done significant improvement. Uttaranchal also made a significant improvement, but a lot of prosperous states, Maharashtra, is not improving. So it's not that education and wealth helps us improve the gender ratio. We are taking the help of law and medication. The law, MTPA, abortion permitted, and medicine where collusion happens. So I think we have to be very, very worried on that one. Rape is another area. Many times newspaper report that doctors have confirmed rape. No doctor can ever confirm rape because rape is not a physical condition. Rape is a creation of law. Intercourse between husband and wife can also result in injury, but that's not rape. Consensual intercourse between husband and wife can result into injury, but that's not rape just because injuries have been found in the vagina does not mean it's rape. It's only when it is non-consensual and not among husband and wife. So it's a legal creation, it's a legal fiction created, and this is a very major fallacy that doctors can tell whether rape has happened or not. Doctors can only tell whether intercourse took place or not, whether injuries happen or not, but whether it is rape or not is a legal field, legal arena. Another thing which has influenced judgments is this Modi jurisprudence on rape, where the sentence which says that a healthy woman, healthy adult woman can resist rape. So if she doesn't resist, the law interprets it saying she was consenting. So when we have two clauses in the rape, so somewhere this whole arena of medical jurisprudence influences the norms or the interpretation of law. So there's another one area I just wanted to flag this. POCSO has created more problems now. Mandatory reporting on doctors. If you don't report of sexual relationship with a minor child, whether consensual or non-consensual, you can be subjected to punishment. And that has also meant a dilemma with the doctors, which is as professional partner with the client confidentiality goals, and also children who may be having consensual sexual activity as a romance category when in their adolescence, they cannot take help from the medical professionals because they will be reported, they don't want anybody to know. Under the IPC, it was only from the age of 12, children could go and consult a doctor, but now because of POCSO, till the age of 18, their consent of the parents is required. So there's again a very major restriction which has happened. Medical treatment of adolescents is what I was referring to. Another problem with the mandatory reporting has been lots of course, doctors would know that adolescent is an age where a lot of things are happening in the mind itself. The neuroscience, brain neuroscience has showed that this is the area of a lot of upheaval and also restructuring in the brain itself. But that has still not informed the law. The law still says that therefore a lot of sexual experimentations does take place during adolescence. And adolescence now has been agreed to be actually going up to 20 and 25. It's not properly informed by the. This was another one which I recently saw in the Times of India newspaper. The MP High Court was dealing with a case where the woman wanted to donate her kidney to her brother, and the doctor said, "Get your husband's permission." So, so doctors have never asked for a permission from anybody if she is donating her kidney to her husband or her son. But if she gives it to anybody in her natal family, doctors say husband ki permission le lo. So somewhere the patriarchal role, and this was very, very eye-opening for me. 4 out of 5 of living organ donors are women. And recipients, 4 out of 5 again, men. So it's very categorically gendered, even though the law is gender neutral. This one is from mothers and wives, sons and husbands. When it comes to the natal family, permission from the husband required, not law. Again, the social norms and the consent in case of husbands and sons, the same way in cases of abortion of female fetus. Is the consent voluntary of the woman concerned? To what is kind of forcing her to or not forcing her? It may be voluntary, it may not be, but we don't ask the question of consent when it is the same family. Not the same family, it is the marital family. So I've already been given the chit just at the right time. And I was looking at the list of the papers presented, a whole new range. But I found very exceptional papers talking on women and gender. So I would suggest, I would hope that some of these thoughts will get into the conversations during the sessions, and you will raise these issues of intersectionality, women, third gender, poor people, minorities, believe the intersection between religious faith and the laws permission. There are lots of intersections that are happening. So thank you very much for this opportunity of me, myself, reflecting on things which were there in the back of my mind, but this conference has brought it to the fore. So thank you very much for this opportunity.
Thank you, ma'am. Thank you for your insightful delivery. Dr. Syed Nadeem Akhtar, sir, our Honorable Pro-Chancellor, Integral University, is a Fulbright Nehru Fellow and serves as the Pro-Chancellor, Integral University. Through his office, drives and execution for the students, the introduction of new programs and collaborations are done. I would request, sir, to kindly deliver the inaugural address.
Professor Dr. Ved Kumari, Honorable Vice Chancellor, National Law University, Odisha. Professor Shikhar Ranjan, Director, Afro-Asian Legal Studies, Delhi. Dr. Kritika Khanijo, the Technical Lead Head, WHO, Geneva, Switzerland, who joined us online. And our special guest, Dr. Gulfam Ahmed Hashmi, the Deputy Director of Health Service Delivery and Human Resources for Health, New Delhi. The Dean of Faculty of Law, Dr. Naseem, and the Dean Faculty of Medicine, Professor Abha Chandra. The Registrar, eminent members of the faculty and staff, my dear students, ladies and gentlemen, Assalamu alaikum and good morning to you all. I realize it is past noon, yet I still choose to say good morning so that some of us who have managed to take a nap can wake up now. It is a privilege to address this esteemed gathering at the inaugural session of the International Conference on the Convergence of Health, bringing together law and medicine. And as we navigate through these fields, we are reminded of their profound impact on the fabric of society and on the lives we aim to protect and improve. Ladies and gentlemen, I am amazed at the kind of intellect and experience present in the hall today, more so on the dais. I listened to Professor Shikhar Ranjan talk beautifully about how the medical practices developed in India. And he was also the legal counsel to the Medical Council of India. Now, I faintly remember that we have had a few run-ins with the MCI in the past, and with a legal counsel as expert, with an advocate as fluent and expert as him, now I know why we could not really win those run-ins. It is probably because of your expertise in presenting this thing. Another very, our chief guest professor, Dr. Ved Kumari, highlighted a lot of disturbing issues in the society, a lot of disturbing issues. And throughout, while I was listening to her, I realized, and she also very rightly mentioned, that law is not the panacea of problems. It is ultimately our upbringing, our ethics that will decide whether we are ethical in our behavior or not. We might be law abiding, but we may not be ethical. And the reason why this happens is ethics and rightful conduct is defined by the one who created us, is defined by the real sovereign, whereas law is made by ourselves amongst us, and that is where the problem lies. Well, I am forced to mention an anecdote here when Professor Ved Kumari mentioned that people were so expert that they just used to check the pulse and diagnose the diseases. So I was told once that there was a very eminent Hakim some time back who used to check the pulses and diagnose the diseases for men, but because he did not really, or he was not inclined to touch the hands of women, so he used to make them stand behind a curtain and have a string tied to the palm and hold the other end of the string and diagnose the disease. So once what happened was he went to a house because the lady of the house had a problem. And what they did was that behind the curtain they put a goat. They tied the string on the neck of the goat and handed the other end to the Hakim. The Hakim held the string in his hand, and after a while he said, "There's not much of a problem. Just add more choker to the gusa and she will be all right." So, so those were the kind of experts that we used to have. Anyways, getting back to my address, and I'll finish very quickly, let me assure you that there is only the presentation of memento to guests after my address. In India, this relationship between law and medicine is particularly intricate, and it is shaped by rapidly evolving legislative frameworks and medical advancements. People have mentioned in detail the Mental Health Care Act of 2017, the regulation relating to medical devices and diagnostics, which is the Medical Devices Rules of 2017, which has created a comprehensive legal structure to ensure that the medical devices in India meet specific standards of safety and efficacy. Then there are legal implications of medical negligence in India that have also led to more stringent diagnostic processes. There is a landmark judgment of 1969 in the case of Dr. Lakshman Balkrishnan Joshi versus Dr. Babu Godbole, related to the operation of a lymph node in the neck. And this laid the foundation for medical negligence under tort law in India, emphasizing the physician's duty of care. There have been several such cases, and many of them have relied on this landmark judgment of the Supreme Court. We had a great insight into the sex ratios in India in the case of childbirth. So the evolution of prenatal diagnostic techniques under the PCPNDT Act, the Preconception and Prenatal Diagnostic Techniques Act of 1994. It highlights another crucial intersection, and this law was enacted to prevent sex-selective abortions by regulating the use of diagnostic techniques used during pregnancy. It mandates stringent checks and balances in the use of sonography and genetic testing, ensuring these technologies are used ethically, aligning medical practice with legal requirements to uphold gender justice. Now, the key word here is ethically. While asking for laddus or burfis to be distributed, we are, in essence, not breaking the law, but we are definitely breaking the ethical code of conduct which we are supposed to abide by. The COVID-19 pandemic, during which our medical college, the Integral Institute of Medical Sciences and Research, did exemplary work in this part of the state, has further illustrated the dynamic relationship between law and medicine. The Epidemic Diseases Act was amended in 2020, along with the Disaster Management Act, and that was pivotal in India's response to the pandemic. It was mentioned by the eminent speaker, Dr. Gulfam Hashmi, that there are discussions regarding the introduction of a right to health bill. Well, I am afraid that this may not go the same direction in which the right to education bill went. The right to education also guarantees free education, free and compulsory education up to, I think, 6th standard to all. But we know that there are several complaints of schools not enrolling students without charging them fees. In fact, the rights as prescribed in the Right to Education Act, if not had today, if not availed today, can be availed 6 months later. If admission doesn't happen today, it can happen next year. No, not much big of a deal. But how about healthcare? If I need a treatment today, I cannot wait for 1 month until the conflict is resolved. So we have to see the how to not merely designing the law, but also how to enforce the implementation. Another aspect which Professor Ved Kumari very beautifully presented was the use of word health and healthcare when related to medicine. And I was reading somewhere that actually, the fruit and vegetable markets, these should be called as health centers. Our hospitals should be called as sick centers or sickness centers, where the sick people go. So when we change this approach, I am sure there will be fewer users of medical interventions and more truly healthy people. The norm, healthy will be the norm rather than unwell. All these fields, the intersection of law and medicine, these are not just enhancing healthcare delivery, but also creating new pathways for professional specialization and development in medicine. And this synergy will ensure that as medical capabilities evolve, they do so within a framework that upholds the law and ethical standards, thereby safeguarding patient rights and the integrity of medical practice. With this, we are truly honored to have the leaders from the leading institutions in India. And I would like to propose that the Faculty of Law at Integral University and the Faculty of Medicine may like to forge collaborations with these eminent institutions represented by their heads here. And I would request our guests to consider collaborating with Integral University so that our teachers and our students can learn more from you, enhance our learning curriculum, activities, etc. Ladies and gentlemen, it has been a crash course for me personally in law and medicine. I have learned a lot, and I have several points that I have to go back and have gain knowledge on, which I will do. I thank you for your attention. I thank you for your attendance here. I congratulate the Department of Law, Faculty of Law, and the Faculty of Medicine for beautifully creating this rare combination of topics, of fields. And I look forward to you engaging in fruitful discussions and innovative collaborations over the course of the day. Together, let us advance the fields of law and medicine, not just in our country, but also across the globe. Thank you so much for your patient learning. Congratulations to the organizers.
Thank you, sir. Some stories are destined to be left unfinished. Some books are left to be unopened, and some memories are left to be unforgotten. I would request our Dean, Faculty of Law, Professor Dr. Naseem Ahmed Sir, to kindly present our token of remembrance of International Conference to all the panel members on the dais. And as the tradition goes, to kindly present the university memento to Professor Shikhar Ranjan sir. I would request Professor Abha Chandra ma'am to kindly present the university memento to Dr. Gulfam Hashmi. Last but not the least, I would request again Registrar Professor Haris Siddiqui sir to present the conference memento to our Dean Faculty of Law, Professor Naseem Ahmed. Now, in the end, as the tradition goes, I would request, sir, please kindly take the seat. Just a vote of thanks is to be delivered. Thank you. Thank you all. I would request Dr. Mirza Junaid Beg to kindly deliver the vote of thanks for the inaugural session of the international conference.
Thank you, ma'am. All thanks to Almighty God. Ladies and gentlemen, esteemed guests, and all the dignitaries, a very good afternoon, all of you. As we come to the close of this momentous inaugural ceremony, I stand before you with a profound sense of gratitude and appreciation. But before expressing anything else, I would like to say something about this very green, clean, neat, and beautiful university. This university has craft and canvas like the well-made style of Sanjay Leela Bhansali. This university have all those things which Sanjay Leela Bhansali executed or and incorporated in his films. And I'm very happy and honored to hear in this university. Now, I would like to express my sincere gratitude to the chief patron of this event and founder and chancellor, Dr. Professor Sayyid Wasim Akhtar sir, for their blessing in his absentia. And now coming to the tribe of this university, the golden tribe, Dr. Sayyid Nadeem Akhtar sir, Pro Chancellor, Javed Musarraf sir, Vice Chancellor, Syed Muhammad Haris sir, Registrar. Their working, their execution, their coordination, their chemistry is just like golden triangle of this constitution, like Article 14, 19, 21. Article 14 stated equality before law and equal protection of laws within the territory of India. Article 19 provides protection of certain rights, including freedom of speech. Article 30 already I have quoted Article 14. Article 15 explicitly talks about women's and children's protection. Ma'am. And last but not the least, whatever faculty convener or student convener, the volunteers, the participants, and dignitaries of the dais and on the dais. Thank you so much.
Thank you. Shouldn't have been a more appropriate thank you note as of the very connection with the Constitution and the university authorities. Thank you, Dr. Mr. Junaid Beg. Whereas now I would be requesting all the people present on the dais and off the dais, plus the participants, for the lunch, which has been organized under the banner of the International. We assemble before the